I think, let's actually start with YouTube.
Okay.
I think there might be less to discuss on that, although people who are not aware of it are going to be learning something.
Sure.
So let's start with YouTube and the $170 million fine issued against them by the
FTC.
In this particular video, we will be having a look at how to evaluate whether you can rely on someone's expertise, even if you yourself are not an expert in that area. It is regarded as good professional practice, if you yourself are not well versed in a particular specialization, to arrange to be advised by someone who does have the appropriate level of expertise in that topic. If you ask for help, you are generally regarded as having reasonably discharged your duty of professional competence. For our case study today, we will be having a look at a conversation between Frei and Nate Broady on Frei's YouTube vlog channel. Frei, as a Canadian lawyer, does not, nor does he hold himself out to, have expertise in matters relating to COPPA. The Children's Online Privacy Protection Act is an administrative law that is the primary basis for the $170 million fine issued to YouTube by the Federal Trade Commission. Acting in a responsible manner, Frei then asked Nate Broady, a former cop, a former prosecutor, and a former law professor turned YouTuber, to provide what is effectively, for our purposes, an informal professional consultation, which the two agreed to make public by streaming it. In this video, we are going to be considering whether we should be relying on Broady's expertise based on his answers to Frei's questions. However, we will also be evaluating Frei's perceived credibility based on two factors. One, what his questions and the way that they are phrased can lead us to deduce about the amount of research he has put into preparation, and two, what his reactions to Broady's answers can lead us to deduce about his general understanding of the law. We do not aim to evaluate any specific legal knowledge either by Broady or Frei. Instead, when we attempt to evaluate whether we ought to place reliance on their legal expertise, we will be evaluating whether or not we perceive their professional judgment to be highly or poorly developed or something in between. It is generally regarded as meeting one's professional duty of competence if one replies that they do not know, rather than making statements which are factually incorrect, or giving opinions that do not have a reasonable basis. We do not criticize either Frei or Broady for making such appropriate admissions. However, when evaluating whether or not to rely on a person's expertise, we do not simply evaluate whether they are making statements that are demonstrably incorrect or not. While this is the first question one tends to ask when evaluating competence, it is also necessary to ask whether the person reasonably should have known the answer.
No, they're going to look just like they did with this lawsuit. They're just going to go on YouTube and look. That's why they call YouTube the barrel and us the fish. They say, YouTube is the barrel. We're going to go on YouTube and just look at it ourselves. And then, the creators are the fish.
Frei and Broady both refer to snippets of the press conference given by the FTC on the topic of the fine. As we have reason to deduce that Frei and Broady were both aware of the information prior to the commencement of the stream, we have to consider whether or not it is reasonable to have expected both to have an understanding of the press conference contents. We would contend that the primary value proposition of a vlog, V-Law-G, channel on YouTube would be the person's perceived ability to synthesize factual information in order to draw appropriate conclusions and make recommendations or advance arguments on that basis, based on their professional training and experience. We posit, based on the considerations we won't expound on in this particular video, that Frei and Broady's audience probably have one of three main motivations for watching their stream. One, they are concerned or frightened by what they have heard in the YouTube community, and they would like to hear a professional's opinion on specific questions. Or two, they would like to develop consolidated understanding of the topic and they are looking for a general primer. Or three, they have some legal background and they are interested in an in-depth legal analysis to hear other professional perspectives. All three of these expected motivations require that the person or persons presenting the topic did their research. However, if we listen to Frei's questions and Broady's answers, more often than not, when they indicate that they do not know the answer to a question, that question was actually asked and answered during the FTC's press conference. It thus appears reasonable for consumers of their content to have expected them to have watched the 40-minute press conference with attention and with comprehension. We should note that Frei's deference to expert advice does not relieve him of his professional duty of research and preparation. He remains the person who initiated the stream and who set its agenda. It could be argued that Frei and Broady's failure to do some very basic research leads to material omissions, which could be argued to unnecessarily increase uncertainty and even panic within the YouTube ecosystem.
Does YouTube not say that you can't use it if you're under 13 years old? Like as a platform, you can't have an account if you're under 13?
Yes, YouTube says you can't have an account if you're under the age of 13. But the government, but that doesn't matter, because what the government does, it says we're not basing it on who actually owns the account, but we're actually basing it on the content. So if you have a video that's directed at children, no matter what account that is, it's the content that's directed at children that they're more concerned about, not the account. If the account says it's from a person who's 100 years old, that doesn't matter. It's the content itself. That's the problem.
This is where, I mean, not having been where the things were pleaded and raised the arguments, where I'm thinking when reading this is that, okay, fine. If they specifically say that children under 13 are not allowed having accounts, therefore anybody who has this account is an adult, is deemed to be an adult or has parental consent. And then they're not targeting children, but they're targeting the behavioral patterns of what can arguably be deemed to be accounts that are more targeting the parents' behavioral patterns for their children, with their children, as opposed to targeting the children and collecting data on children, as opposed to collecting data on parental accounts for children. So not knowing if any of this was argued, we know the outcome was...
Well, they settled because the law is pretty clear. It's about the content. If the content is targeted toward children, then that content, you can't collect data on that content. It's not about the individual, it's about the content itself.
Firstly, there was the issue of whether or not the fact that YouTube requires a user to be over 13 in order to be able to create an account should absolve them of legal liability. Broady correctly points out that COPPA prohibits the collection of data based on whether the content is deemed to be child-directed or not. However, both fail to address the fact that an account is not required to access the YouTube sites, and if and how that impacts such a defense. Both also fail to consider whether or not the way in which YouTube asks the user for their age would meet the FTC's requirements for neutral verification. For example, according to the FTC, a checkbox requiring a user to tick that they are over 13 would not qualify as neutral verification. However, most importantly, both fail to consider that where content is child-directed, which needs to be distinguished from family-friendly content, the FTC prohibits the site or part of a site like a channel to prohibit users of under 13 from accessing it. Thus, to use the most commonly cited example of Ryan's Toys review, such a channel is clearly unlikely to attract any significant viewership from teenagers or from adults, as the target audience is clearly children of approximately Ryan's age. Therefore, Ryan's parents and lawyers cannot claim to comply with COPPA by prohibiting children from accessing their content. Furthermore, even if some parents are watching with their children, COPPA specifically requires parental consent for data collection to be verifiable. The site also has to provide a privacy policy that is displayed prominently, detailing the types of information collected and how that information is used. And they are required to provide a mechanism for the parent to find out what information is being held about their child and to demand for the information to be promptly deleted. Under the frequently asked questions about COPPA, the FTC states what is and what is not considered to be verifiable parental consent. Neither Frei nor Broady appears to have read the frequently asked questions on the FTC's website. Frei's assertion that he would base a defense on the fact that the parents are deemed to have consented therefore shows a lack of even the most rudimentary understanding of the COPPA requirements. While Broady's explanation that it is the nature of the content and not the actual age of the user that determines whether or not it is subject to the provisions of COPPA does indeed address the heart of the matter, the appearance of incompleteness may mean that it is not appropriate or advisable to rely on Frei or Broady's expertise as displayed in the specific stream. It may indicate that Frei and Broady's stream cannot be considered a comprehensive primer on the basics of COPPA or the impact that the FTC's fine of Google and YouTube may have had on the YouTube creator community, which, as we have stated, is one of the three main reasons we expect anyone would be watching the stream. People within the YouTube community have a demonstrable interest in content that will allow them to understand how they, as channel owners, are impacted by COPPA. We should state here that Broady did bring up elsewhere in the stream that individual channel owners have strict liability, something for which he does deserve credit. Also, he explains that it is necessary to check the box that a particular video contains content directed at children when that feature becomes available to avoid one's channel being held liable for non-compliance with COPPA, again for which he does deserve credit. However, he did not make it clear that their COPPA obligations are retroactive and that the settlement between the FTC and YouTube did not include an agreement of retroactive immunity for channel owners. As this information was included in the FTC's press conference, of which Broady was aware, it does appear to be a material omission in his analysis.
Well, no, we're talking about the monetization.
Oh, barely. Yeah. So what are going to be the actual impacts monetization-wise on those types of videos?
Well, understand this: directed ads that are directed toward the individual, where your individual tastes that are following you and finding out what you actually like. Those ads are so much more expensive than just the ads where I just on a football commercial, I'm just doing beer commercial for everybody playing football. So those directed ads, channels who are deemed to be child related or to be marketing to children, they're going to lose, they assume, about up to 85% of their ad revenue if they are deemed to be focusing on children, because the ads that are just the general basic ads that you put on every video are just so much less appealing that a lot of these channels, these bigger channels, are looking at 85% of their income being lost through ad revenue because of this new rule.
Yeah, and so for anybody who doesn't really understand that or never thought about the monetization, there are two systems. There's like you pay just for the ad and run it anywhere, or there's the auction-based ad. And so some of these big companies, when they know that they can target someone specifically who would be most likely to open up the ad, they'll pay a substantial portion of money to be able to directly target that individual. What, from what I understand, is going to happen now is that companies like Lego are not going to be able to specifically target children's Lego channels because they're not going to have that data any longer. So it's going to be like sort of the generic splash all ads, which people pay much less for because they're not specifically targeted.
Correct. Not toward the individual, which makes.
Is it demonetized, or are they running limited ads? Well, so apparently there's only two icons. There's green and there's yellow. Green being monetized and yellow being demonetized or limited ads. And then apparently, from what we learned with Jörg Sprave on the last live stream, even if it's got the green icon, if it falls into certain categories where advertisers aren't really willing to splurge on advertising, it might be monetized in reality, but demonetized in behind closed doors type thing. So
Frei and Broady also appear to display a lack of comprehensive understanding of YouTube monetization. When asked whether kids' content will be demonetized or just placed in a limited ad state, neither Frei nor Broady explained that contextual advertising or targeted advertising can apply either to fully monetized or to limited ad states. Nor did they make it clear that being placed in a limited ad state means that an advertiser's product, like alcohol for example, is unlikely to be suitable to display to young children. Broady does mention that the specific user cannot be targeted, but the implications of this do not appear clear from his analysis. During the FTC's press conference, the Bureau Director explained that while targeted advertising based on personally identifiable information collected from children is not allowed, contextual advertising is allowed. It may be worthwhile to include here that Lego will still be able to target ads based on titles or videos or keywords that include the word Lego. They could even place ads on videos that have titles or keywords related to their competitors' products. What they will not be able to do is determine how many times a particular user has seen their ad or otherwise track their progress down the sales funnel. That is to say, the primary benefit of behavioral advertising is actually less in the initial defining of the target audience than it is in the ability to retarget someone for advertising. That also ties in with the claim that creators' bottom lines will be severely affected. Frei and Broady repeat the claim that these creators may lose up to 85% of their revenue based on the fact that advertisers will no longer be able to target their advertising on a specific user's behavioral and demographic data.
I know that on YouTube, for example, the kids market is the most valuable market. Like like the best month, I'll get like $3 CPM. That's like my best month ever. Kids content, I'm talking 10.
What they fail to account for is that the CPMs are said to be somewhere between $1 and $2 per thousand views for news and opinion type channels, while there are claims that creators of children's content can earn between $10 and $25 per thousand views. If we take the higher end of $2 for other creators and the low end of $10 for children's creators, that means that an 80% reduction in revenue that creators of child content would be earning approximately the same per thousand views as creators of other types of content. And that is without accounting for the fact that children are still a valuable target audience, and that demand may be less elastic than accounted for in those estimates, at least after the panic dies down, if advertiser and user confidence can be sufficiently maintained. Frei did allude to this by saying that the price may settle somewhere in the middle, for which he does deserve credit. However, it was not clear from his analysis why that might be the case. A possible reason why CPMs on children's content was 5 to 12 times higher than CPMs on other types of content is possibly because it allowed advertisers to obtain, to store in databases, and to track, with seeming plausible deniability, personally identifiable information about children that they were not legally allowed to access. It is well known that illegal goods and services have a price premium due to restricted supply, which could account for the significant price differential. If the measure of the quality of a vlog is indeed whether or not watching it would lead to a better or more nuanced understanding than investigating the primary sources for yourself within a roughly equivalent time frame, then it is our personal conclusion that a user would have been significantly better served by watching the 40-minute press conference by the FTC chairman and bureau director. If the user wanted to spend another hour or so investigating the topic, it is our personal conclusion that they would have been better served by reading the frequently asked questions about COPPA directly on the FTC's website. While Broady in particular is very personable and relatable, it does in fact appear he does in fact appear to exhibit expertise in the legal field, the possibly material omission of significant considerations and facts, and the lack of research into questions both Frei and Broady could have reasonably been expected to have an understanding of, given their professional backgrounds, may affect their credibility in the mind of a reasonable independent observer.
Do we know how they got to $170 million for the fine? Was that like a reflection of, apparently that was 10 times the largest fine that the FTC had ever previously issued?
Yeah, it was the largest fine they've ever for this particular thing, 170 million, which is a lot of money. But it didn't go to the people who they actually violated. It went to the government. This is nothing for YouTube, because don't forget it's the Google conglomerate. So they're making money hand over fist. They probably threw out a number. They said, "Well, give us your best number." They probably 170. Okay, we'll pay it. Don't worry about it. Yeah,
and that's when the FTC says, "Damn, we should have asked for 270."
While the FTC bureau director did not explain in detail how the $170 million figure was arrived at, he did indicate that it was calculated as a multiple of revenue, and that certain factors, like the fact that they would have had to prove specific knowledge for each individual channel had they got to court, affected the specific calculation of the multiplier. This is something both Frei and Broady could have reasonably been expected to have knowledge of if they had watched the FTC's press conference, which we have already established they were aware of.
And that's interesting. So they've given a deadline for YouTube to, what do they have to do? They have to purge the system of all this data they have. How do they confirm that they are deleting this data that they've gathered illegally?
Well, I don't know if they have to delete the data they already have.
The FTC press conference also addressed whether or not the data which YouTube allegedly illegally collected would have to be deleted. The bureau director indicated that YouTube would not be allowed to use for any purpose, even a purpose allowed by COPPA, any data so collected in terms of their settlement with the FTC. This is again something both Frei and Broady could have reasonably been expected to have knowledge of. There are a number of other examples where the information presented in the stream could potentially be regarded as materially incomplete, particularly in reference to the distinction between family-friendly content and child-directed content and general audience content and potentially adolescent content. However, to keep this video to a manageable length, we will not be addressing those here. Keep an eye open as we will be addressing some of those topics in future videos.
Do we know that it's going to be retroactive or only going forward? Like, is it going to apply to content already out there that's been out there for years?
I don't know. I actually don't know. But again, I would suspect if YouTube has to be in compliance with the law, then even that older content has to be identified, which child related, because if you have content that's child related that's still getting, this type of information, then you're violating the law. So they have to have some type of mechanism to either, stop that from happening or, to figure out that it's child related content.
Amazing. And then Albina Verpa says, so is the FTC going to put out what is deemed to be child content? I mean, that's going to be the question. That's probably what's going to be the first major defenses of any suit that get out there is it's not child content, it's adolescent content. Or I tell you though, my defense would have been that these accounts that are for 13 and under really are the parents' accounts, and that this is not targeting the children, it's targeting the accounts that have that behavioral pattern, but they ought to be governed by the parents, and the parents, in having allowed the channel to be created, deemed consent to that type of advertising. But I guess
but again, that's a good argument. But the counter to that is that it's not based on the account; it's based on the content. So if the content is child-related content, then it doesn't matter who's watching. It doesn't matter if if only adults watch it. The fact that it's geared toward children is the violation of the law.
Frei's perceived credibility and presumption of professional competence could have been well served by doing better research prior to discussing a topic which is as pertinent as the changes to kids' content policies is to the YouTube creator community currently. His insistence that he would have argued that there is deemed parental consent, even to the end of the show, even after Broady's explanation that YouTube's alleged liability was grounded in the fact that COPPA regulates child-directed content in and of itself, regardless of the age of the actual user, as well as the fact that YouTube could apparently be demonstrated to have had actual knowledge of such child-directed content on their platform, does not reflect a favorable perception on his general understanding of the law. We are not intimating that Frei is not professionally competent. Instead, we consider the possibility that he is not delivering as well as he possibly could or should have on the primary value proposition to his audience, which we posit is to provide a more nuanced understanding than the viewer's own interpretation of the primary source material could have done within a comparable amount of time. Not delivering on a core value proposition may place a provider of a good or service at risk of being strategically outcompeted in the marketplace. At the time of this recording, to the best of our knowledge, we do not have any current or prior affiliations with any of the third parties referred to in this video.